Morning. Okay, looks like the first individual we're gonna see this morning is Adrian Rico. Followed by Timothy Holbeck. And then I've gone through each one of these files, probable cause sheet, court assessment notes, as well as the risk assessment. So I'm familiar with the facts of each case. More interested in failure to appear to comply and safety to the community. All right, is the state ready to proceed with Mr. Rico?
Yes, Your Honor. Good morning, Kelly Costo, representing the state. The state seeking $20,000 with no 10% cash alternative for Mr. Rico. That is based on the Category B felony robbery with a deadly weapon. The state believes that bail is necessary based on the facts of the case outlined in the probable cause declaration, as well as his moderate score of 8 on the risk assessment. He is 28 years old. His criminal history, we know that he has a traffic matter pending in Reno Municipal Court. He was arrested on that. That was earlier this year. And when he was arrested on that offense, he had an outstanding bench warrant from a different matter in Reno Municipal Court. That's from a 2022 citation for driving without a valid driver's license and no insurance. He failed to appear in that matter, and a bench warrant was issued for his arrest. Like I said, when they went to pick him up on the 2025 offense, they arrested him on that bench warrant in that new case. He does have juvenile history as well, but no other history other than those matters that I've told the court. But again, based on the nature of this offense, the violence, the use of a deadly weapon, a firearm, the state believes the $20,000 with no 10% is appropriate. We would ask for pretrial supervision with a no firearms clause, as well as a no contact order with the victim of the case.
Right. We have a response.
Yes, Your Honor, we're going to be asking for a release on his own recognizance today. In looking at the NPRA, we have had the opportunity to speak with his wife, Maria. She confirmed that he has a residence at 3200 Lakeside Drive. She confirmed that he works at Corey's Lawn Service, and she confirmed that he does have a phone number. So with those changes to the NPRA, it would take him down to a low risk of a 4. And we are hoping that you review that to see that a release on his own recognizance is appropriate. Looking here, it appears that substance abuse, specifically alcohol, may be at issue. My client is willing to do any sort of conditions of no alcohol, testing for alcohol, and plans to enroll in some sort of classes. He doesn't have any funds to make that amount that the state is asking for, and we are requesting that OR, Your Honor.
All right, well, he's not eligible for an OR given the facts of this case. Yeah, I did pull a gun on the victim in this case. He hit it in the trash can and he ran from officers. So, but what I am going to do, it is going to be a no 10% cash given the charge in this case. It'll be $10,000. He'll contact with the name victim Alex Lopez Lucille. He'll be subject to testing because he did indicate he'd been drinking. Shall not possess firearms or weapons. He must reside at 3200 Lakeside Drive, Unit 51, and he'll be subject to supervised check-ins. All right, next is Timothy Holbeck.
It just says contact with BAS.
Was the state able to notify the victim in this case?
We were, Your Honor. We were able to speak to Monica Holbeck, who is the minor's mother.
Oh.
All right.
So, Your Honor, based on reviewing the nature of the offense, as well as speaking with Ms. Holbeck, which I'll detail for the court, the state is seeking bail in the amount of $20,000. Again, that would be with no 10% cash alternative based on the Category B charge of child abuse. The nature of the offense, obviously, the defendant is in possession of a firearm when he goes into the 17-year-old's room. He scores a 6 on the risk assessment, which is moderate. He wasn't able to provide a reference. The main reason for asking for bail is his history as well as speaking with Ms. Holbeck. We know that the Ms. Holbeck currently has taken out a TPO against, or has been granted a TPO against this defendant. That TPO does involve the minor children, including the victim of this case. He was convicted in 2024 of domestic violence violation of a TPO that was out of Sparks Municipal Court involving Ms. Holbeck. In 2022, he was arrested for child abuse and domestic battery. It was the same victim at the center of that case, as we see here. That case ended up being dismissed based on insufficiency of evidence. And then finally, back in 2014, he was arrested for domestic battery. It eventually was dismissed. I'm not sure who the parties were in that case. In speaking with Ms. Holbeck, she did say, again, she does want that no contact order from the court, even though she already has the TPO. She said that she is very afraid for her safety and the safety of her children because the defendant has very erratic behavior, which we can see outlined in the probable cause declaration. She said that she believes that he uses controlled substances on a daily basis that contributes to the defendant's erratic behavior. And as far as weapons, she said there obviously was a shotgun during the incident. He also had a rifle and a handgun when they were married, so there's a possibility of other firearms. So for all of those reasons, and based on the victim's wishes as well, the state believes that some bail is appropriate. We're seeking that $20,000 with conditions of no contact with the minor child, as well as no firearms or weapons, as well as testing for controlled substances and or alcohol.
So do you have the child as Donovan Holbeck?
Yes.
And then do you also have the address, 1552 West 7th Street?
Yes, Your Honor. I don't, it sounds like that maybe is the defendant's residence. It sounds like mom has taken the children and trying to get sole custody of those children. So I'm not exactly sure what her address is. I can try to find that.
Okay. All right, do we have a response?
Yes, Your Honor. In the case at hand, according to the probable cause sheet, Mr. Holbeck actually was the one that called 911. I believe that this is a cry for help. Mr. Holbeck is a veteran. He has been suffering from mental health as well as substance abuse issues, and it appears that they're going through a divorce, which is adding to those issues. He wasn't arrested right away. He was actually arrested at the VA because he went over to the VA to get help. And at the time he was arrested, he had help lined up. He was going to go to the Lionheart inpatient program, which is an addiction and mental health court program. And this is where he was going to go, but then he was arrested by RPD prior to being sent to that program, but it's all lined up. We are asking that you release him on his own recognizance so that he can go home, get some clothes, check into the VA, and go to the Lionheart program as it's all ready to go. And that's our request, Your Honor.
Okay. Do you know if he has an alternative place to live? Were you able to verify his information?
Your Honor, we were able to verify that he is a veteran, that he was seeking help at the VA, and we've confirmed that he lives at 1552 West 7th Street.
But isn't that where the incident took place? That's his address?
And then that's his house, Your Honor.
In the,
Okay.
I was calling the truancy officer because my son hadn't been to school in 2 weeks.
And I think he was calling the truancy officer because his son hasn't been to school in 2 weeks. So there's a lot of family things that are going on here. I don't know if, yeah. So we would submit with our request, Your Honor.
And Ms. Costa, were you able to verify that there's another address here? So you can return to 1552 West 7th Street?
I just pulled up the TPO, Your Honor, so I should be able to get it off there.
Okay.
Hold on one moment.
And then let me ask the public defender, do you know if CPS is involved?
We don't know at this point, Your Honor.
Yeah, that's what they indicated in the notes. All right. All right. he was uncertain whether CPS was involved. Do you have an answer for me, Ms. Casso?
As far as the address, Your Honor, listed on the TPO, which says it's not confidential, so I'm okay to give it to the court. It's
Well, I just
115.
need to know, I don't need to know that address. I just need to know that it's not 1552 West 7th Street.
It is not. It is a different address.
Okay, that's what I needed to know. All right, but the facts are concerning of this case. I got a similar incident with the same victim. So his bail is going to be set at $10,000, no 10% cash option, no contact with Donovan Olchek. He'll be subject to drugs and alcohol testing. He must comply with CPS if CPS is involved. He must reside at 1552 7th Street, and he'll be subject to supervised check-ins. You're able to get him into a facility, you can always, the notes are going to reflect that you can always reapply. If you can get him a direct transfer or something of that nature. All right. Next is Michael Clark.
Your Honor, there's a request for clarification on whether you're ordering alternate or DAS supervision.
Yes.
It says you're in contact with them within 24 hours.
Yeah, my understanding is DAS is
Hang on,
still an entity. Still provides supervision, and the judges are working with the stakeholders to continue DAS going into the future. So for right now, it's still going to be DAS supervision. All right. Michael Clark, ready to available?
Yes, sir.
Are we ready to
Yes,
speak with Mr. Clark?
Your Honor, it appears that he was planning to retain, so I don't know if you've appointed us in this case. My understanding is the state will be asking for an OR, which we are not opposed to. So I don't know if it's necessary to appoint the public defender.
Well, I did. He did indicate he was going to retain, but until he retains somebody and that new lawyer files the notice of appearance, I've got the public defender as defending Mr. Clark till he can get substitute counsel. All right, so is it accurate that the state is going to recommend an OR?
Yes, Your Honor, cautiously. And the difference between this defendant and the last defendant is, number one, this defendant's 67 years of age. He does score 5 on the risk assessment. He does have a prior conviction from July of this year of violating a domestic violence or a court order preventing domestic violence. That's out of Sacramento. However, the difference is we spoke with the victim in this case. She said she's not in fear for her safety. They are going through a divorce. They have never had an instance like this before. She wanted the court to know. She still wants to talk with the defendant based on going through the divorce and the separation of property. She said that she does believe the defendant has issues with alcohol, which is obviously borne out with the probable cause declaration. And
Right.
she said she doesn't believe he has firearms based on that prior TPO, but the state's going to recommend an OR at this point, but we would ask for some strict conditions, which would include DAS supervision, no firearms, relinquishment of any firearms to law enforcement, a daily alcohol testing at the onset, as well as testing for any controlled substances or use of marijuana. And I believe that was all the conditions.
All right, I just wanted to confirm. In the notes, it said that Mr. Clark reported he and the alleged victim are no longer living together. The incident occurred, it looks like it's 788 Country View Court. So does he have another address that he can go to? Public
No.
defender, no?
Your address?
That's my address, and my wife has moved her stuff out, and she's is living somewhere else. The only reason she was at home today is because she's taking her things out.
Okay. Let me just check with the district attorney. Did Ms. Clark want a no contact?
She's not asking for a no contact order, Your Honor.
So, Mr. Clark, your residence is 788 Country View Court?
Yes, sir. Yes, Your Honor.
All right. Let me just finish my notes on this case. All right. So there will be an OR release. There will be not going to impose a no contact order. You'll be subject to testing for daily alcohol tests and random testing for other drugs. Shall not possess firearms or weapons. Must relinquish those firearms. The other condition I'm adding is you must reside at 788 Country View Court. You're going to be subject to supervised check-ins by DAS. All right. Other than that, you're going to be released, sir.
Don't do it.
Just go ahead and sign right here. It just says you're gonna make contact with the AS.
All right. How about Lewis Dawson, followed by Cheyenne Lindy, I think it is. All right, so this is a lengthy probable cause sheet as well. Just like yesterday. Is the state ready to proceed?
Yes, Your Honor. Your Honor, state seeking $100,000 with no 10% cash alternative. Based on the residential burglary charge. We're also asking for DAS supervision, which would include house arrest and GPS prior to release. And no contact per court order with these the two different victims as well as their residents. We
Okay.
believe that higher amount of bail is necessary based on the facts as outlined in the probable cause declaration, in addition to his very lengthy criminal history. You can see he scores highly on the risk assessment at a 12. He's an active rope target. He was graduated from specialty court this year, just earlier this year, on a possession of a controlled substance case. When I looked at the docket or procedure for that case, he had 5 different pretrial violation reports during the pendency of that case. All of them included testing positive for controlled substances. In 2023, he was convicted of obtaining money by false pretenses, a misdemeanor out of Reno Justice Court. He was released on his own recognizance in that case. That own recognizance was later revoked. He's got a trespassing in 2021, a drug paraphernalia in 2020. He's got a misdemeanor conviction for failure to appear in 2019 out of Sparks Municipal Court. He's got a felony conviction that year for possession of a controlled substance for the purpose of sale. He was discharged on his probation on that case in 2022. Another felony conviction, or excuse me, he's got misdemeanors in 2009 for drug paraphernalia and possession of a hypodermic device. He has then felony convictions for battery with a deadly weapon in 2008, but he wasn't discharged from parole in that case until 2016. He has a felony conviction for attempted burglary back in 1995, felony conviction for possession of stolen property in 1994, and a burglary conviction back in 1994. So very lengthy criminal history. Although some of those felonies sound older, he was on probation or parole for an extended period of time. So the defendant's been in and out of custody since 1994. Again, based on the very detailed probable cause narrative, state believes that there's a good probability of conviction in this case. This was a very large amount of money that was stolen as well. So the state believes that the higher amount of bail is appropriate.
All right, do we have a response?
Yes, Your Honor. Mr. Dawson simply is not able to make that high amount of bail. He is able to afford approximately $1,000 in cash and would ask that his bail be set at that amount. As the district attorney pointed out, he recently did graduate drug court, so he is able to comply with conditions, very stringent conditions that we see in those drug court programs. And that would be our request, Your Honor.
So I'm gonna set his bail at $75,000, no 10% cash option, given the facts in this case. He took $80,000 in cash from the victim, stole 5 guns and pawned the jewelry. Caused a lot of damage in this case. He'll also be subject to residential confinement, fitted before release, subject to drug and alcohol testing, shall not possess firearms or weapons, and he'll supervise check-ins with DAS. In addition, he shall have a no contact order with Bruce Weber, Deborah Bearden, 850 Hahn Drive. And I also have Ledges Bay Casino and Dottie's Casino, where basically he spent their money. All right, so given the facts of this case, bail is appropriate. All right, next is Cheyenne.
Here.
Followed by Brett McCartney. All right, stay ready to proceed.
Yes, Your Honor. Your Honor, the state seeking $5,000 bail for this defendant. She only has one prior conviction, but she's on probation for that conviction, and there is a warrant out for her arrest related to that conviction, which is the gross misdemeanor, promote distribution of a controlled substance. That is out of the 4th Judicial District Court. It's mentioned in the probable cause declaration, I believe. So she does have, I believe, have a hold for that bench warrant. So based on that and the facts of the case, the state believes the $5,000 is appropriate. We would ask for pretrial supervision along with testing for controlled substances.
All right, do we have a response?
Yes, Your Honor. Miss Lind is unable to make any sort of cash bail. We would request a release on her own recognizance. She is agreeable to those conditions. She wants to get substance abuse help. We were able to talk with her mother, and we were able to confirm that she does have a cell phone, which would bring her NPRA down to a 5 from the 6. And with that, would submit, Your Honor.
Were you able to verify that she lives at 543 West 6th Street, Unit C1?
Her mother was not able to confirm that. She didn't know her address.
Why don't you ask your client, does she reside there?
And my client does state that is where she resides.
Okay. All right. I'm gonna set her bail, but it's gonna be $3,000 or 10% cash open based on her risk assessment. She'll have no contact with her co-defendant, Matt Brooks. She'll be subject to drug and alcohol testing. Other conditions is they must verify that she lives at 543 West 6th Street, C1, and she'll have supervised check-ins with DAS. She needs to verify that she has a place to live. All right, next is Brett McCartney,
So they're in my contact with the warehouse foods.
followed by Charles O'Neill. Looks like we have 2 for Mr. O'Neill. All right, stay ready to proceed with Mr. McCartney.
Yes, Your Honor. State is seeking $50,000 for Mr. McCartney, and we would ask that it have no 10% cash alternative based on his continued conduct, similar conduct as you see in this case. Obviously, very
Right.
concerning that law enforcement shows up and the defendant is passed out in his vehicle. He scores a 9 on the risk assessment. We know, as mentioned in pretrial services paperwork, that he was arrested earlier this year in May for DUI drugs out of Grass Valley, California. Assuming that case is still pending. There's no disposition on his criminal history. He was arrested for felony DUI out of Washington last year. Again, there's no disposition on that charge. It's possible that it's related. It doesn't have a case number to his 2021 felony conviction for DUI out of Washington. Like I said, that was in 2021. In addition to that felony, he's got a 2016 gross misdemeanor arrest for hit and run and DUI. It appears it was deferred and dismissed. That was out of Washington in 2016. In 2014, gross misdemeanor conviction for DUI out of Washington. Same thing in 2012, DUI conviction out of Washington. 2010, a misdemeanor conviction for possession of marijuana out of Washington, and then a possession of drug paraphernalia back in 2008. So defendant has very similar conduct. Obviously, this is going to be a second or third felony DUI, depending on how it shakes out. But either way, it is a mandatory prison sentence. The state believes the bail with the no 10% cash alternative is appropriate, along with pretrial supervision with testing for controlled substances and alcohol, and a flat out no driving clause. There's no way this defendant has a legal license at this point based on his numerous convictions for DUI.
And then the probable cause sheet indicated he had, let's see. All right, so just said prior DUI convictions. Looks like he was convicted of felony DUI on 3/5/21. And could you repeat, do you have more recent ones?
I do show that he was arrested in Grass Valley, California on May 25th for DUI. There's no disposition to that one yet, but that charge is showing up on his criminal history. And then in 2024, it does show an arrest for DUI felony out of Washington, but sometimes it's hard to tell whether that's a probation violation or if it's related to the original arrest in 2021. But either way, there's no disposition for that one either.
All right. All right, do we have a response?
Yes, Your Honor. Mr. McCartney is requesting a release on his own recognizance. We were able to contact his mother, Rosemary. She confirmed that he lives at 131 Highlands Court, Grass Valley, California. She confirmed that he's self-employed as a window cleaner, and she also confirmed that he does have a cell phone, which would bring down his NPRA score. And we are requesting that release on his own recognizance because he has no finances to make any sort of cash bail.
All right, understood. There's a substantial issue with safety of the community. Setting his bail at $50,000, no 10% cash option, subject to testing drugs and alcohol. Since he's a convicted felon, I've got shall not possess firearms or weapons. Other conditions is he must reside at 131 Highlands Court, Grass Valley, California. They'll have no driving whatsoever, given the facts of this case, and they'll have supervised check-ins. All right, next is Mr. O'Neill. Got two cases for Mr. O'Neill. So which one does the state want to do first?
Your Honor, we can argue both of them at once if that's okay with the court.
That's fine.
The state's going to be seeking $10,000 on the controlled substance case, along with conditions of DAS and testing for controlled substances. As to the residential burglary case, the state is seeking $15,000 along with the no 10% cash alternative based on the residential burglary charge. We would seek DAS supervision and with a no contact order with the victim, as well as a no firearms or weapons clause. The state believes both those bails are necessary, again, based on the facts of the case as outlined in the probable cause declaration. He scores moderately high on the MPRA. However, the defendant does have prior violent history to support that bail. We know that he was convicted in 2022 of a felony domestic battery with substantial bodily harm out of our second judicial district court, in which he was sentenced to prison on that case. That same year, he had a destruction of property conviction out of Reno Justice Court. He has another felony conviction, this time for possession of a firearm during a drug trafficking crime. That is a federal conviction. He received a sentence of 72 months, and then he was granted 36 months of supervised release. It looks like he was released from that supervision in sometime in 2021, and we know he immediately then gets convicted of the 2022 domestic battery felony. Another felony back in 2004, this time for assault with a deadly weapon out of our Second Judicial District Court. A separate conviction for carrying a concealed firearm out of our Second Judicial District Court. And then a separate conviction felony for possession of a controlled substance, all in that year. And then finally, back in 2003, he was convicted of robbery with a deadly weapon. Looks like he went to prison. He was discharged from parole on that case sometime in 2010. So not very long periods of being out or not on supervision for this defendant. He has a violent history. Obviously, the facts of the residential burglary are violent, so the state believes that the previously asked bail and conditions are appropriate.
Right, do we have a response?
Yes, Your Honor, we are going to be requesting a release on his own recognizance because Mr. O'Neill does not have any funds to make any sort of bail. If you are going to be setting a bail, we'd hope that you would consider to allow him to be transferred to an inpatient program once that's lined up. We were able to speak with his girlfriend, Aaliyah. She does confirm that he lives with her at 1550 D Street in Sparks. She also confirmed that he has a working phone number, which I believe would lower his NPRA score down to a 6, which is a moderate. And with that, would submit, Your Honor.
What address did you verify where he can live?
1550 D Street.
You say
In
E as in Edward,
D as in dog.
in B Street in Sparks?
D as in dog street. D Street.
Oh.
In Sparks. Yes. And we
Is
do
there
have a,
unit number?
is there a unit number?
I don't think so.
No, Your Honor.
Okay. All right. Well, on the possession drugs charge was 18.7 gross weight. Instead of the 10,000, it's gonna be 5,000. He'll be subject to drug and alcohol testing. Shall not possess firearms or weapons. He must reside at 1550 Z. As in Zorro Street, Sparks. He'll be subject to supervised check-ins. On the other case, those facts are much more concerning. Using a metal rod to attack his neighbor. So his bail is going to be set 15,000, no 10% cash option. All right, no contact with the named victim, Sidney Boyle. No contact with 1400 East 4th Street, Unit 35. It's protected property. To be subject to testing, shall not possess firearms or weapons, and again, supervised check-ins with the AS.
Those are in like
All right.
24 hours. Being used.
Next is Joshua Patrick Lawrence, I believe.
I don't know. Bill.
Followed by Oscar Martinez. State ready to proceed?
Yes, Your Honor. Even though the defendant was overridden on his risk assessment, the state's going to not object to releasing the defendant on his own recognizance. He has no prior criminal history other than traffic-related offenses, and that is what pretrial services was referring to when they said he didn't take care of matters. However, there are no
Right.
Criminal convictions, so no objection to OR with testing, with supervision and testing.
All right. It looks like they were able to verify his place of residence. Does he reside at 4705 Amber Hill Lane? We know.
Yes.
Yes, Your Honor.
All right, so you're gonna be OR'd, you must reside at that address, you'll be subject to testing. And supervised check-ins with DAS. All right,
Today. Check in with you.
Center at the bottom. Make sure you talk that to release.
all right.
Date.
We have a date,
November 13th at 9 AM.
so November 13th, 9 AM will be his next hearing date. That's the same hearing date for anybody that's OR'd, correct? Okay,
Or you know, okay.
okay, what about Mr. Martinez? Muscaso,
Same thing for Mr. Martinez. The state's not going to object to releasing him on his own recognizance. I don't believe any conditions are necessary other than reminders for court. Although he's only 18, he doesn't have any prior criminal history, adult criminal history.
So really, there's no victim in here, but his, is there gonna be any no contact with 1140 Jones Street? Looks like his girlfriend is named ABAH Lawrence. So no contact? State doesn't need a no contact order?
Judge, I would ask for the no contact with the apartment complex. I wouldn't ask for the no contact with his girlfriend, but it's probably a good idea to stay away from the apartment complex.
Right. And no supervision?
I don't believe it's necessary.
All right. All right. So I'd also flag this one for an OR release, given the circumstances. So you're gonna be released, sir. There'll be no contact with 1140 Jones Street. Otherwise, show up for your hearing dates. The next hearing date is gonna be November 13th, correct? At 9 AM will be your
Your
next
Honor.
hearing date, sir.
Your
Yes.
Honor, Mr. Martinez is from Kentucky. He actually has a flight home the 1st of November. Is he going to be allowed to appear virtually for that hearing?
Yeah, what he needs to do is set a Zoom request.
Contact your attorney. Zoom request.
And those are typically granted if they live outside the state. All right? But you have to submit a formal request, all right, sir?
Yes, sir.
All right, you have a good day.
Okay.
All right. How about
Zoom request is already closed.
Haley Lynn, MIDDUGH, followed by Sean Knott. This is the co-defendant with Joshua.
Yes,
All right,
Your Honor.
does the state ready to proceed?
Yes, Your Honor, we are asking for bail on this defendant's case based on her history of noncompliance. We're seeking $3,000 with DAS and testing. As you can see, she scores high on the risk assessment out of 12. Almost every prior case she has a compliance issue. I show that she was cited for trespassing out of Reno Municipal Court in 2023. She failed to appear in arraignment and a bench warrant had to be issued for her arrest. That is the bench warrant that she was arrested on in this case when she was contacted. In 2022, convicted of possession of drug paraphernalia out of Reno Municipal Court. She failed to appear for her community court hearing and a bench warrant was issued for her arrest. 2021, another conviction for possession of drug paraphernalia. Again, she failed to appear at arraignment and a bench warrant had to be issued for her arrest. Then she has 2 more prior convictions for possession of drug paraphernalia, one out of this court in 2018 and another one out of Reno Municipal Court in 2019. So the defendant, again, has compliance issues. So the state believes that a smaller amount of bail is appropriate based on her flight risk of that $3,000 with testing.
All right. We have a response.
Yes, Your Honor, we are asking for a release on our own recognizance. I don't know what the distinction of posting $3,000 would make for compliance, but I think something that could confirm compliance would be those bail conditions that we are agreeable to have testing. It's necessary for my client to get treatment. I believe if you're unwilling to reduce to an OR at this point, we would request that you consider that in the future if we're able to set that up. As for supporting that, we were able to confirm her address at 1405 Sky Mountain Drive, apartment 126 in Reno. We did talk to her mom. That is where she lives. And we've also confirmed that Ms. Mida has a telephone and we have that phone number for you as well. And with that, we would submit, Your Honor.
Let me ask you this, Ms. Casso. Let me just confirm something here. I was looking through this file. Thought there was an indication that she was your client's interested in substance abuse treatment. Is that accurate?
Yes. Yes, Your Honor.
So, Ms. Casso, I don't I don't see why we would, if she's eligible for direct transport for inpatient facility. That might be an option in this case.
I don't disagree. Unfortunately, again, she has that compliance history. They've tried to help her in community court. Obviously, she didn't show up, but based on the amount of controlled substances, the state wouldn't object to releasing her directly to an inpatient treatment program.
All right, so let me adjust my JRO.
You'll have to be transported directly to an inpatient. That's what he hopes. So they'll help you with an inpatient.
All right, so her bail is going to be set at $3,000. She'll be subject to testing. She must reside at 1405 Sky Mountain Drive, Unit 126. If she's able to post, she'll have supervised check-ins. However, she will not be required to post bail if she gets a bed at an inpatient facility and she's directly transported there. So that would be the exception in this case. So if she's not able to post, then she has to find a bed in an inpatient facility with direct transport in order to be OR'd. Okay?
This is your contact with DAS.
Next is Sean Naughton, followed by Michelle Watkins.
Your Honor, Mr. Naughton has waived his appearance. We are prepared to proceed, and I've informed the district attorney that we will be requesting an interim bail to be set to explore competency issues.
All right. But Ms. Costa, what's the interim bail?
You want to state seeking $5,000 along with DAS supervision and testing for controlled substances and alcohol.
All right, so I have those on my JRO as well. But I do have a no contact with Matt Townsend, 2590 Orvada Street. His bail, interim bail will be set at $5,000, subject to those conditions. All right. Next is Michelle Watkins. Okay, David, ready to proceed?
Yes, Your Honor. Your Honor, based on the facts of the offense, the state's not going to object to releasing the defendant on our own recognizance. We are asking for DAS supervision, and we would ask for a complying with CPS provision of that pretrial supervision. Again, the defendant does have prior, as outlined in the probable cause, does have prior arrests and convictions surrounding similar incidents. However, based on the facts of the case, we're not going to object to an OR release.
Okay, let me ask you this though. Let me just double check something here in my notes. It indicated she doesn't know where the children are, or CPS is, or doesn't know whether CPS is involved in this case. Was the public defender's office able to verify any of that information?
Your Honor, we do not have any of that information at this point in time.
Does your
But I
client
believe-
know if CPS is involved?
She does not know, but she believes they are.
Okay. And then I noticed, Ms. Costa, you didn't add the children as part of the no contact. What I have is no contact with the minor children unless CPS allows supervised visits.
That's fine, Your Honor. That's fine. I'm sure CPS has some type of provision in place, and we were asking for comply with CPS provisions, but that's appropriate.
All right, so you'll be released, miss. No contact with the minor children, which is Kalea, Helen, Jeremiah, and Michelle, unless CPS authorizes contact with the minor children. Must comply with CPS. All right. And you have supervised check-ins with DAS given the fact that you've had two prior similar cases, relatively recent. You should only be allowed to see your kids as long as it's supervised by CPS until they say otherwise. All right, otherwise you'll be released, miss.
Let's go consent right here. It just says-
And then your date will be November 13th at 9 AM will be your next court date. All right, I'm showing Michelle as the last individual. Is that accurate?
That's correct, Your Honor.
All right, you all have a good weekend.
Thank you, Your Honor, you too.
Thank you.
I mean, I got an A minus?